Hello, landlords. It's Ernie Garcia, landlord attorney, and today we are featuring an uncontested eviction. Let's get started.
The next case is Gustavo Nades versus Steven Alvarado. Steven Alvarado, are you here? Case number 29722.
So, whenever an eviction case is filed, the court prepares the petition and sends it out, which is called service of process, to the defendant, the tenant in this case, with what's called a citation. This is that official looking first page of the lawsuit that identifies the court in the county with the contact information for the judge and where the tenant should appear for the eviction trial itself. Along with that is a petition that's filed by the plaintiff making the allegations for the eviction. The defendant should be given notice at least 6 days in advance of the eviction trial. If that citation comes to the defendant in fewer than 6 days, the defendant is entitled to an automatic reset of the trial date, and courts will honor that, of course, because at least 6 days must be given to each tenant before any eviction trial. Of course, a tenant who shows up and is ready for trial can waive that extension of time. But in this case, we're dealing with a tenant who didn't show up. And so whenever a defendant fails to appear, although ordered to appear in this citation, they are subject to what is called a default judgment.
All right, Mr. Nades, I'm going to just go ahead and ask you some questions. Go ahead and make this process go a little bit quicker. Is Mr. Alvarado still in possession of the house?
According to my parents, because I'm calling from offsite, I'm working as the agent for them. They're the landlords. They happen to live right across. They haven't seen this truck in a few days. Like I said, he hasn't declared he's not there, but it seems like it's been vacant.
Now, in this case, the judge asks specifically about possession, usually for one of two reasons. The first is to make sure that the petition was correctly filed. You see, if you send a notice to vacate to a tenant and they actually vacate before you file, well, then your eviction petition is improper. You can't evict them if they've already left. Additionally, if a tenant leaves at a certain date and your trial is, say, 30 days later, there's probably an amount of time for which you cannot recover rent because you're limited to the amount of time in which the tenant actually occupied the unit. So possession of the premises is important. In this case, it's really unclear whether or not the tenant has actually vacated. There's a suspicion that he has, and that's the best that the plaintiff can testify to.
What is the past due rent, no late fees?
Past due rent is for the month of June for $600.
Any government housing applicable here?
Not applicable.
Okay.
Now, in this case, the court asks about unpaid rent. Remember that in an eviction trial, only unpaid rent can be awarded. Well, it's true that court costs and attorney fees can also be awarded, but things like late fees or unpaid deposits or pet fees or damage to property, none of that stuff comes in an eviction matter. And so you are limited to unpaid rent in an eviction. Additionally, the court asks about government assistance. Was there government housing or a housing program that was responsible for the payment of any rent? Sometimes a person has violated the lease and is being sued on a non-rent basis. And so just because the rent is a certain amount doesn't necessarily mean that the court will award that amount in rent, especially if a government agency has already paid that rent. So these are important questions that the court is going to ask of the landlord, and you as a landlord should be prepared to answer. If there is government assistance and you have received even a partial payment of the rent, you must disclose that to the court in order for the award to be accurate with the facts of your case. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing.
Did you give notice to vacate?
Yes, we gave notice to vacate on May 17th. He verbally agreed at some point, then retracted on his statement, and then we generated this eviction case that we're on today.
Okay, and it was filed with the court. Therefore, judgment by default for possession, past due rent in the amount of $600, and all cost of court.
In this segment, you see that the court asked about the notice to vacate, whether it was delivered, when it was delivered. You didn't hear the judge ask how the notice was delivered. And you're going to find that different courts in different counties are a little more strict or a little more lenient when it comes to the notice to vacate. There are some courts that your case lives and dies by that notice to vacate. They ask that you submit it to the court, and then they hold you to Chapter 24.005 of the Texas Property Code, which explains how that notice to vacate is supposed to be delivered. Now, we always recommend that landlords deliver their notices by regular and certified mail. We say and, not or. By regular and certified mail. This is your best bet, and we found it's the most effective way to prove that the notice to vacate was delivered. But you can also deliver it by posting it on the inside of the main entry door or by placing it in the hand of either the named tenant or an occupant 16 years of age or older. If you deliver it in some other way, chances are pretty good your case is going to get shut down. But not if the court doesn't actually ask. In this case, you didn't hear any questions about the method of delivery. You simply heard, was the notice delivered? And the facts in the testimony were a bit thin, but it was made to the satisfaction of the court, and that's really all that matters when, especially, the defendant is not there to object. Now, the procedure is much more formal on the appeal, and we'll talk about appeal a little later in this video.
I'll set a bond at $1,200 for the appeal. In the event he wishes to do that, he'll have 6 days to do that. If he's not out by then, you or whomever can come get the writ of possession in a week.
Now, at the end of the eviction trial, the court will set an appeal bond. Now, this is set because every single case that comes out of the Justice Court can be appealed. It has nothing to do with whether or not the landlord did anything wrong. It has nothing to do with whether or not the defendant actually has a viable defense to present to the court on appeal. It has everything to do with the state of the law. And the law says that every single order that comes out of the Justice Court is subject to an appeal. The court will set an appeal bond. It's usually some multiple of the amount of monthly rent. However, there are multiple ways that the tenant can appeal. A cash bond is not the only way that a tenant can appeal. For more information on the way that tenants can appeal, we've made tons of videos on the subject. You're welcome to watch all of the appeal videos that we've got on the subject, whether that's by cash bond, by surety bond, or by affidavit of inability to pay. We've got videos on all of those topics.
Do you have any questions of me, sir?
Yes, given that we're kind of assuming that he has left the property, should we wait till the date that you indicate to actually take possession back?
Absolutely. The way the law looks at it, if he tenders the keys back to you, he's gone. If he hasn't tendered the keys back to you, he's considered still there. And what you might consider trash might be treasure to him, and we don't want any further obstacles down the road, if you know what I'm talking about.
Yes. Okay, I understand that, and I'll go by that.
Okay. Finally, what I found particularly interesting about this trial is the bonus content. The judge was willing to answer the question of this plaintiff. You're going to find that in some courts, the judges are a bit hostile when it comes to answering questions or giving what they consider free legal advice, whether it's to a plaintiff or to a defendant. And there are some that lean one way more than they lean to the other. But many judges will just shut down whenever a question is asked, and they'll simply say, albeit politely, that's something you should refer to your attorney for. And so in this case, the plaintiff asked a procedural question: what do I do when it comes to recovering possession? And the court says, well, you're gonna have to wait. And the truth is that your lease might give you certain other rights. And so naturally, if you come to an attorney, we're gonna have a different opinion than what the court says. The court assumes that your only option is to follow the court order, but your lease might give you certain other options, including to inspect the property, including to declare any personal property that's left behind abandoned, and there's sometimes a procedure in your lease for making that declaration. It usually involves leaving some kind of notice, giving a certain time period, and then coming back and emptying out the unit if in fact you can in good faith determine that items have been abandoned. And so you might want to wait for the writ of execution or the writ of possession to be exercised, but that's not necessarily a requirement in all cases. So, yes, you can ask. Don't be surprised if the court shuts you down and says, nope, not answering that question for you. But if you do have questions, the best source is not the clerks at the court. It's not the judge, him or herself. It's usually a licensed attorney. And so we recommend and urge you at all times, if you have questions for us, my contact information is here on the bottom of the screen. You've probably seen it throughout the video. We encourage you to reach out to us. And if you have questions, ask those questions before you get into a tight situation. Or if you're at the end of, or whatever part of your eviction, you have a question, don't hesitate to give us a call or shoot us an email. We're happy to help out wherever we can. And if it turns out you need to hire us for legal representation, well, we're pretty good at that too.
Okay, very good. Then I'm going to go ahead and end this session here. Thank you so much.
Thank you.
Bye.